If you're an Alberta-based employee and you've recently been let go from your employment, you may have a number of questions about your severance entitlements. I'm Mike from Cash and Legal, and in this video, I'm going to discuss severance pay in Alberta. At the end of this video, you will have a better understanding of your severance entitlements and what you should focus on when negotiating severance with your employer. First and foremost, in order to understand how to negotiate your severance package, it's important to understand what severance is. What we commonly refer to as severance in Alberta is actually pay in lieu of notice. In order to understand this distinction, I'm going to explain what pay in lieu of notice is. At law, employer's obligation is not to provide severance on termination, but to provide notice of termination. This means that an employer is required to tell you ahead of time that your employment will be terminated at a later date. In practice, employers generally provide pay in lieu of notice instead of providing notice itself. This compensation provides employees with the earnings they would expect to receive had they been given the opportunity to work through their notice period. For example, if someone's entitled to 12 months of notice, the employer has an option for terminating the employee's employment. They can either provide the employee with 12 months of working notice, or they can provide them with 12 months of pay, representing their notice entitlement. Understanding that your severance package is actually pay in lieu of notice is key to successfully negotiating your severance package. In addition to understanding the concept of notice, it's also important to understand why employers are required to provide you with notice. Understanding the source of this obligation has a major impact on determining the amount of severance you're entitled to receive. In Alberta, there are 3 distinct sources for the entitlement to notice or pay in lieu of notice. The first source of this entitlement is the Alberta Employment Standards Code. This is a piece of legislation that governs employment relationships throughout the province of Alberta and generally sets minimum standards by which employers have to comply when they're treating their employees. Under the code, almost all employees are entitled to a basic amount of minimum notice, which can be provided as pay in lieu of notice. Your notice entitlement under the code is solely dependent on the length of time that you've spent working for your employer. The minimum notice entitlements established by the code are not significant. For example, under these minimums, if you've been working for the same employer for more than 10 years, you're only entitled to 8 weeks of notice or pay in lieu of notice. Given that these amounts are relatively low, employees are often curious to know whether they can seek more than these minimums. This brings us to the second source of your entitlement to notice, which is your employment contract. If you have a written employment contract with your employer, it may contain language affecting your entitlement to notice or pay in lieu of notice. If you have language in your employment contract that addresses your entitlement to notice, this can have a significant impact on your severance package. There are a few important things to note here. Many employment contracts contain language that attempt to limit the employee's entitlement to notice to the mandatory minimums set forward by the code. However, the courts have been clear that very specific language is required in order to limit an employee's notice entitlement to these mandatory minimums. The language in your employment contract must clearly and unambiguously limit your entitlement to those basic standards. If the language in your employment contract doesn't meet this rigorous test, the clause may not be enforceable. Further, the amount of severance payable pursuant to your employment contract cannot be less than the mandatory minimums set forward by the code. If the terms of your employment contract attempt to deprive you of the mandatory minimums set forward by the code, these terms are not enforceable. The final source of your entitlement to notice is common law notice or reasonable notice. If you do not have a written employment contract with your employer, or if your employment contract doesn't specifically address your entitlement to notice or pay in lieu of notice, then you are entitled to common law notice. Common law notice is an implied term in employment agreements that provide that an employee is entitled to reasonable notice of the termination of their employment. It's important to note that not every employee is entitled to common law notice. The terms of your employment contract can eliminate your right to common law notice, but again, there's a very stringent standard for the language that needs to be present in order to do this. Much like language limiting your entitlements to mandatory minimums, the language must clearly and unambiguously limit your right to common law notice. You're probably wondering how common law notice is calculated. Some people will tell you that common law notice is determined with reference to a fixed rule of 1 month per year of service worked with an employer. However, the courts have regularly dismissed this argument, and in fact, there is no fixed calculation for common law notice. Your entitlement to common law notice is actually dependent on a variety of different factors, including your age, the length of service with your employer, your position with your employer, and the availability of alternate employment. When determining how much common law notice you're entitled to, the law will look at these factors as well as other different factors to determine what's fair in any given case. Given that there is no fixed calculation for common law notice, a significant amount of severance negotiations in Alberta are focused on how much common law notice an employee is entitled to. Once you've determined the length of your common law notice entitlement, you can calculate your best case scenario severance package by extrapolating your earnings over that notice period. Before I move on to the important things you need to know when negotiating your severance package, I want to address the issue of just cause terminations. The information I provide in this video regarding notice entitlements is applicable to without cause terminations. A without cause termination occurs whenever your employer is simply letting you go and isn't alleging that you've committed some serious breach of the employment agreement. In our experience, the vast majority of terminations are without cause terminations. However, in some circumstances, employers will attempt to terminate your employment for just cause. This will occur if you commit a serious breach of the terms of your employment agreement, such as stealing from your employer, lying to your employer about something serious, or committing an act of serious, willful misconduct in the workplace. If any one of these things occurs, your employer will likely attempt to terminate your employment for just cause. And when an employer terminates for just cause, you are not entitled to any notice or pay in lieu of notice. It's important to note that if your employer has alleged just cause at the time of termination of employment, that does not mean your employer in fact had just cause to terminate your employment. If your employment has been terminated for cause, I strongly encourage you to seek legal advice, and you can do so by clicking the link to our website in the description of this video and booking a consultation with our office. There's one final concept I want to cover before I get into the important things you need to know when negotiating your severance package. This is the concept of mitigation, which refers to your obligation to make reasonable efforts to mitigate your damages if you are seeking additional severance from your employer. Mitigation is very important to understand because it can have a significant impact on your severance entitlements. This can happen in two ways. One, if your severance case goes all the way to court and the court determines that you did not make reasonable efforts to search for and obtain alternate comparable employment, the court may arbitrarily reduce the amount of your severance entitlement. For that reason, if you're engaged in a prolonged severance dispute with your former employer, it's important to search for alternate employment and also to document those search efforts. Secondly, the other way that mitigation can impact your severance entitlements is that if you find alternate employment within the severance period, this can reduce your severance entitlements on a dollar-for-dollar basis. With all that covered, I'm now going to share some important things you should know when negotiating your severance package. The reality is you should not focus on getting a severance package that aligns with your best day in court. There are a few different reasons for this. The first is mitigation. Employers know that you have a duty to mitigate your damages and that obtaining alternate employment can reduce the amount of your severance entitlement. For that reason, employers factor the possibility that you may mitigate your damages in any offer that they make. The reality is that there is a strong possibility that you do obtain alternate employment while your severance negotiations are ongoing. For that reason, there is value in accepting a fair offer even if it doesn't align with 100% of your full legal entitlement. The second reason for this is legal fees. To obtain a severance package that is 100% of your full legal entitlement, you will have to obtain significant legal fees in order to achieve this result. Contrary to what most people believe, legal fees are often not fully recoverable in legal disputes. In fact, sometimes these disputes resolve with each party paying their own legal fees, even if you're able to obtain more severance from your employer than was originally offered. The third reason you should be prepared to make concessions when negotiating your severance package is litigation risk. Pursuing legal action against your former employer involves a multitude of contingent risk factors, most of which you have no control over. Any one of these factors can significantly shift the trajectory of your severance negotiation process. For that reason, there is often significant value in making concessions during the severance negotiation process. And any lawyer who is telling you the truth will acknowledge the validity of these points. Having said that, not every situation is the same, and there are circumstances where it makes sense to pursue your full legal entitlement. The second piece of advice that I'd like to share with you regarding severance negotiations is don't sign the offer from your employer right away. If you've been offered a severance package by your employer, it likely includes a requirement that you accept the offer by a specific date. Even if that date is fast approaching, I strongly encourage you to obtain legal advice before accepting the offer. If you need more time to review the severance offer or obtain legal advice, request an extension. In our experience, employers are almost always willing to grant extensions on severance offers. You should also absolutely not feel pressured to sign the severance offer. And if your employer is unduly pressuring you to sign the offer, this is improper. My third piece of advice for negotiating your severance package is to understand the terms of your employment contract. Your employment contract may include numerous different terms that impact your severance entitlements. For example, if there is a clause in your employment contract that limits or affects your entitlement to pay in lieu of notice, this should definitely inform your severance negotiation strategy. Further, there may be terms in your employment contract that impact how different forms of compensation are treated during the termination process. Understanding all of these legal nuances is important for both assessing whether the offer from your employer is fair and for developing a strategy to provide compelling counterproposals. My fourth piece of advice is to use your leverage. If you have a substantial claim for severance against your former employer, this might be an opportunity to renegotiate terms of your employment contract that might impact your employment moving forward. I'm specifically talking about non-compete and non-solicitation agreements. If your employment contract includes clauses that purport to impact your ability to compete with your employer or to solicit business from your former employer's clients during the severance negotiation process, you can agree to accept a lower severance in return for a release from these obligations. It's important to identify these issues at the beginning of the severance negotiation process to determine whether any of these opportunities exist for you. My fifth and final piece of advice for negotiating severance packages is to understand the terms of the document that you're being asked to sign. If you've been offered a severance package that exceeds your basic minimum entitlements, you will likely be asked to sign a release in favor of your employer. It's important to understand the terms of the release before you sign it, because sometimes these releases contain terms about what you can and can't do moving forward. For example, releases commonly feature confidentiality or non-disparagement clauses, and if you breach these clauses later on, it can impact the severance package that you receive from your employer. Additionally, if your severance is being paid out as a salary continuance, there's a possibility the release contains a clawback clause. A clawback clause provides that if you obtain new employment during the salary continuance period, this either ends or reduces the amount of severance your employer has to pay you moving forward. It's important to understand how these clawback clauses work because they will impact what you do with the next steps in your career. If you've recently been let go from your employment and you're looking for advice or assistance with respect to your severance package, we can assist you with this. We provide employees who've recently lost their job with clarity about their severance entitlements, strategies for negotiating better packages, and peace of mind through sound advice and strong representation. If you'd like our assistance with your severance package, click the link to our website in the description of this video and book a consultation with our office today.